Good afternoon, friends. So, I'll be giving this important talk on guidelines and the law. Where is the balance? So, this talk I gave it in Hicks 2020 webinar meet that was conducted on 20th June 2020. So, it's a good topic, and I enjoyed preparing for this topic. So, I thank my good friend Samvedam in giving me this talk. So this is a good cartoon where you see there is a lawyer arguing with the judge that the doctor is liable to be ignorant because he has not followed the guidelines. So this is what this cartoon says. So as doctors, we all need to understand. So what is the balance between guidelines? Are we mandated to follow the guidelines, and would we be found guilty if we have missed out any aspect of the guidelines? So that is what we are here to answer. So, as back as 4th century BC, Plato, who is a Greek philosopher, he mentioned that the doctors should form a council and they should exchange info in the council, and they should express their major views in the council, and they should codify whatever has been expressed in the council has to be codified. And way back in 4th century BC, he emphasized that whatever has been codified should be published, and this published material, which later was called as guidelines, is what should be followed across the board. So this is expressed way back in 4th century BC. And to that effect, even Plato expressed his apprehension that even with these guidelines that is expected, that is to be followed, so there is an expertise also that needs to be demonstrated. So what he meant was there should be flexible responsiveness to work around the guidelines, and there should be ability for a clinician or an expert to improvise the guidelines to deliver the best care to the patient. So even this he put in his views that although majority of the doctors agree upon certain aspects of practice, they codify it and publish, but experts should have ability to work around the guidelines and improvise it based on the clinical situation or in the clinical or the given clinical context. So even there it was referred that the ability to customize the care also should be there and work around the guidelines. So this is what was mentioned way back in 4th century. But now we are increasingly seeing this aspect of flexible responsiveness or working around the guidelines and improvising it and customizing the care is getting endangered, because most of them are adhering to the guidelines as a sacrosanct or as a gospel or as a prophetic way. So the guidelines is referred to as a debased form of practice. So when we say debased form of practice, it means the guidelines are worked by creating a model patient. So we presuppose an average patient. What that means is you take an average patient and you consider and you extrapolate the guidelines that are worked for that average patient to all the other different dimensions of that patient, which means, so if you have a sepsis, we understand that sepsis is not the same in all the 10 patients that you treat. They all behave differently. But the guidelines are prepared keeping certain set of variables in mind and prepared. So that's why it not necessarily applies to the various spectrum of presentations of that disease condition. So the knowledge and analysis that goes through the guidelines not necessarily takes into the cognitive process that is happening in the clinician caring for the patient. Rather, it looks into the cognitive process of the guideline maker. See, whatever is running in guideline maker's mind is what he will put in into an average sort of a patient that he will presuppose, and not necessarily it will take into context all the clinical cues from various spectrum of clinical presentation. So this is what is the limitation. That's why we call it as a debased form of practice. And there is also a reference to limitation of guidelines, because the guidelines is not thorough proof mechanism. Just because someone has followed a guideline doesn't ensure that your clinical outcomes have been improved in a given patient in a given context. So that's what, so not necessarily you can say just because I followed guidelines this patient should have become better. So it does not mean that. So it does not mean just because you applied guidelines it has improved the clinical outcome. And evidence, so we understand that guidelines are linked to the evidence, because whatever guidelines we put, most of it would have been derived from the guide evidence, or some of it would have been derived from the expert consensus. So what, even if it is linked to the evidence, the guidelines has to be interpreted sensibly, and it has to be applied with discretion. So just because guideline is there, we cannot apply it homogeneously to all the patients. So it has to be customized, it has to be applied with discretion, or and in many instances it may have to be refrained from being applied also. So these are some of the things that we need to bear in mind. So let's go through the examples. So when you look at UK, United Kingdom or England, so it looks at obviously the minimum accepted standard of care. This minimum accepted standard of care that is expected out of a clinician is not derived from the guideline. Rather, it is derived from the responsible customary practice that is prevailing in that geographical location. So it does not look into guidelines as a standard of care. Rather, it looks as a responsible customary practice as a standard of care. And the clinician, another important caveat of guideline is if clinician implements faulty guideline to a patient. Suppose a patient is there and patient is a cardiac patient and you applied sepsis guidelines. So it is not the fault of the guidelines. So the liability lies with the clinician. So ultimately, the ball is in clinician's court. So whatever he may say that I thought it is sepsis, I've applied this guideline, but the liability is not with the guideline; it is with the clinicians if it is applied in a faulty way. Okay, so that is also a caveat that one we need to keep in mind. And NHS, National Health Service guidelines clearly says that guidelines does not mandate, does not authorize, does not outlaw the treatment practices that are prevailing. So guidelines are not a rhetoric that, or it's not a commandment that it has to be followed. So it does not mandate. So it is only a guide. It is only a reference point for you to um, practice, to help you practice what is largely accepted. But it does not mandate or does not authorize or does not outlaw the whatever practice patterns, customary practice patterns that are prevailing. So the French governance has looked into the biases that may be prevailing in the guidelines. So it highlights, the French social security system does highlight that many of the guidelines that come have elements of biases embedded in them. And the cartoon that they have depicted is this, and this is a good analogy they have given. So a fabled drunkard who is looking into his lost door key in below the street lamp, because he looks into the lost door key under the street lamp, because that is where the light is, although the door key is lost in some other place. So what that means is that you are trying to look for the truth within the guidelines, because that is the mandate that is given to you when the writing is on the wall, and when you know the things are very different, but still you are trying to extract the information from what it may not be available in that particular guideline. So this is the analogy the French social security system has given. So now the question in mind for all of us is, by not following guidelines, are we legally liable? So for that, there is a very important thing that you need to understand. So in US and Europe, guidelines are harnessed to regulatory tasks. So if a guideline is linked or harnessed to regulatory tasks, then it may have legal ramifications. So I'll give you an example. So in UK, they came out with this Human Fertilization and Embryology Act in 1990. So it's an act of the Parliament. So this act said it offered, or it delegated this to a regulatory authority to create guidelines. So by an act of Parliament, it delegated this task to a regulatory authority, which I would believe it would be NHS, which would have taken on to create a guideline. So the guideline said that only three fertilized ovumes and not more than three fertilized ovumes can be placed in a womb of a lady. So if a clinician or a practitioner breaches this and he embeds more than three fertilized eggs, which is considered a transgression of the guidelines, which is linked to the regulatory authority, which is linked to the Act of Parliament, then there will be a liability of a fine or even revoking of a license was made. So, which means when a guideline is harnessed or linked to a regulatory authority, it becomes a prescriptive legal rule. That is where you can have a legal liability. If you have not followed that, you can be sued in the court of law and you may become liable in the court of law. So, in the French system, the French social security system, they came out with 147 mandatory practice guidelines which are linked or harnessed to regulatory authority, which means you are mandated to follow that. If you do not follow that and you have a lawsuit against it, you may be vulnerable for criminal or legal liability. So they came out with 147 mandatory practice guidelines in 1993, which was called Lloyd 2 9398, which encompasses the investigations, treatment, because it's a social security system, investigations, treatment, and certain therapeutic intervention and the surgical aspects. So, but these guidelines, which was linked to the regulatory authority, was involved or was mandated to determine your reimbursements to private practitioners and reimbursement to the health authorities or the health councils. So this is where you see. So what this means is, if you have not followed these mandatory practice guidelines, then you may not be eligible for the reimbursements. So that again is a caveat which where you will be mandated to follow guidelines. And I'm sure this is happening in private healthcare also, where many times, especially in US, you are linked to the insurance company. So if you have not followed the mandatory guideline which is linked to the insurance or which is linked to the regulatory authority, then your insurance will not be given. So these are some of the caveats which are evolving from the guidelines. So you need to be aware. So where you are caught up with. So by not following certain guidelines, first thing is you should ascertain whether your guideline is linked to a regulatory authority. If it is, so the typical example I can give is the present prevailing COVID situation in India. So in COVID-19 situation, all the guidelines that are coming from government of India is linked to a regulatory authority because it's coming from this government. So if we do not follow the guideline that is coming from a regulatory authority, which is government, honorable government of India, and you are filed a lawsuit, so you would become culpable or you would become liable for having not followed a regulatory guideline that has come in from Government of India. When I say Government of India has mandated ICMR to be a regulatory authority. So it flows like that. So if you have not followed a guideline that has come from ICMR, which is Indian Council of Medical Research, so there is a possibility if a criminal law or a lawsuit is filed, that culpability is possible. That's what it means. So, and even the French Social Security mandates that these mandatory guidelines, when it is published, it becomes an enforceable agreement. So now having clearly understood as to where the guidelines are placed. So for all the listeners, guidelines linked to regulatory authority, take it very seriously. Guidelines not linked to regulatory authority. So I can say the Indian Society of Critical Care Medicine guidelines. It is not linked to any regulatory authority. It is not linked to mandatory guidelines. Suppose if some of our guidelines is taken by ICMR and say this is the gospel to be followed, then it becomes a regulatory guideline. So none of our societal guidelines could be taken as a mandatory regulatory body linked guidelines. So that is the difference. So having done that, but that does not absolve you if you have done something erroneously negligent. So then we need to understand what is standard of medical care. So standard of to ascertain to ensure if the clinician has followed standard of medical care, what is universally accepted is application of this Bolam test. So Bolam test is a very historic test that came in 1957, which was a um, case between Bolam and Fran Hospital. So where judges note in Bolam test, what judges note is there is a minimum standard of care that is expected out of a clinician to have delivered to the patient, and that special skill, whatever he is credentialed to be. So suppose if a intensivist, there are certain procedures or certain skills that he is expected to demonstrate or he is credentialed to demonstrate, and judge is only ascertaining if that special skill is exercised. And even there, judge acknowledges even in that standard of care there can be two schools of thoughts. So, like a simple example, suppose there is a lawsuit on an intensivist, and then intensivist has possibly not used steroids in septic shock. So again, there are two schools of thoughts there. So judge recognizes that, because there is one school of thoughts which may say there is a strong evidence that we should use corticosteroids in septic shock. There may be other, there is not there may be, there is other school of thoughts which say they don't believe in steroids in septic shock. So judge acknowledges that, and that takes into due consideration. When that situation arises, what judge does is he will refer it to the expert opinion, so expert team. So what listeners need to appreciate here is your expert opinion or expert panel that is created by the court of law is placed at a much higher pedestal than the guidelines. So that is why there is a lot of emphasis or lot of sort of a leverage for the seniority of the practitioners or the experience of the practitioners or the academic standing of the practitioners, that becomes more valuable than the guideline. So this is what we need to, all the listeners need to clearly understand. Because I've been part of an expert panel where we have given inputs for such situations where the court of law obviously looks into our state medical council, and our Karnataka medical council appoints the expert committee where we give our inputs. So that is how it works. So the typical example is this case, Cranley versus Medical Board of Western Australia, that came in 1990, where injection diazepam was given to a patient who was a heroin addict, and this did not comply with national methadone guidelines. So this is a regulatory, because this has come from the national guidelines, and it is a national which is harnessed to a regulatory body. Because it was not complied to a regulatory guideline, the court pronounced him guilty for infamous and improper conduct. So that was Dr. Cranley. Then when this case went to Supreme Court, obviously Supreme Court nominated an expert panel, and expert panel did subscribe to the fact that the practice of giving diazepam is an acceptable practice in a small proportion of a different school of thought, and he was pronounced not guilty, and so the case was dropped. So this is a typical example how the court works. So court does not take guideline on the face value and pass the verdict. Rather, it refers to the expert panel, and the decision of the expert panel is taken into cognizance before the verdict is passed on proving guilty or not proving guilty. So this is a typical example that is cited. So the good thing about Bolam test is Bolam enshrines the standard of customary care, and it takes into cognizance all the prevailing evidence regarding the question in mind, and it does take into cognizance the evolving standard of care with regards to whatever contentious issue that may be in discussion, and most importantly it takes into cognizance the professional experience of an individual in question and professional inputs that comes from the expert opinion. So that is the beauty of Bolam test, and it is professionally led. Difference of opinion is taken into account, deliberated, discussed, and it takes into cognizance all the range of medical practices that may be prevailing, as you saw in the Cranley versus Medical Board of Western Australia. So that is the beauty of Bolam test. And another apprehension of guidelines is widespread adoption of guidelines without improvisatory ability, without our ability to work around or customize the care, or our ability to improvise, will take clinical care as a normal standard, and it will not take into account the customary standard of care that may be prevailing. So I think this is something. So basically, following guidelines blindly without applying our mind, or without customizing to the patient, or without our ability to improvise, is not something that is in the best interest of the patient. That is also accepted by the court of law. So, in summary, what you need to know is, if a lawyer or anyone shows clinical guideline, it is not a substitute for the expert opinion. So ultimately, court looks into the expert opinions mandate to determine, the negligence, or to determine the verdict of the pay. And guidelines is not a gold standard. And court also acknowledges that just because you are compliant with guideline, that you have followed a reasonable or you have followed or delivered a reasonable standard of care is not what that it accepts. Just because you are not compliant with guidelines, court does not consider that as negligent. So court does not really say, oh, you have followed guidelines, so you are okay. It does not say that. You can still be culpable even if you have followed guidelines and applied it in a wrong way. And just because you have been not followed the guideline, you have done something, even then it doesn't say it is negligent. Ultimately it will refer to the expert opinion. Expert opinion will make an analysis and give a report to the judge, and he will make a call based on that. This is what I want listeners to understand. To that effect, listeners need to know what is negligence. Negligence is, first thing is, you have accepted the patient and you have owed allegiance of duty of care to the patient. So once you have taken the patient under your treatment, it means you have offered your duty of care, you have owed duty of care to the patient. And after having owing the duty of care, there has been a breach in the care that you have provided, and that breach has caused the harm to the patient. And the court looks into, or the expert opinion, if they look whether this harm that was that happened to the patient, was it foreseeable and was it reasonably avoidable. So this is what the court looks into. So these are the important dimensions that court looks into to determine whether someone is guilty or not. So now coming to the authors of the guidelines, whether authors are liable. So the authors of any guidelines are not liable for incorrect or misleading statements, and there is no duty of care of any of the authors of the guidelines towards its readers. So ultimately, the court recognizes it is the reader who should interpret whether the guidelines that is narrated applies to the patient he is treating. That's what it all boils down to. Unless you prove in the court of law that the author has foreseen or has foreseen that what is communicated in the guideline is impelling the reader to follow what is written and has not left him with much choice of other options, then only the authors can be liable, which is remotely possible. Unless you are proving that author has written something which has forced the reader to follow that and reader did not have any options, unless you prove that, so the authors are not liable. And even it says, even any of the organization or institution that has come with guidelines, like Indian College of Critical Care Medicine, if it comes with a guideline, Indian College of Critical Care Medicine cannot be held responsible for any pitfalls that may happen in applying that guidelines. So this is also very clear. So, if you want to really keep your guideline very safe, then you can do something called prefacing the guidelines with multiple statements. So, this the British people do it very well. The example is in 1977, the British people came with these guidelines for malaria prevention for its travelers going to Africa. So, when they came out with a guideline, they prefaced with multiple statements like this. They said the guideline is by experience, it's on professional opinion. It's an opinion, and the guidelines has inadequate data to give unequivocal views. And then whatever guidelines is given is only an acceptable options. And even the drugs that is listed in the guidelines is licensed, and it is the responsibility of the licensing authority if they use it. So basically they put all this as a disclaimer, and at the end they write guidelines to be read as supplement. So which means you have prefaced your guidelines with multiple of these disclaimers so that you keep it as legally safe. So this is also recommended. So if you consider the guidelines that you are issuing would have some legal ramification, put a disclaimer. Like the example I can give is when I put up a guideline for our Karnataka state for COVID, we came out with a guideline. I put a disclaimer: none of the drugs that are recommended are a standard of care, and this is something that will evolve over course of time. So we put up a disclaimer. I put it as a disclaimer, so that would keep it safe from legal entanglement. And again, the court recognizes guidelines historically that have been taken into account to prove someone negligent is only less than 7%. So it has not had a great value in proving anyone as negligent. And every clinician, it is expected to apply the guidelines with appropriate clinical discretion and take the expert inputs before you apply the guidelines if you are in doubt. Okay. And even if guidelines is linked to as a legal standard, there can be sensible discretion that can be applied whilst applying. And the court also recognizes what this discretion is. Discretion is readiness to deal with each case on its merit. So still, even though your guideline is harnessed to a regulatory authority, is harnessed to a legal body, still you can apply your discretion, and court recognizes that discretion is acceptable. Discretion basically means customizing to the patient on board. So guidelines are there to assist, cannot mandate or authorize, cannot outlaw treatment practices, and cannot coerce an individual to follow what is written. And guidelines, there are certain philosophy behind guidelines, that it has to be extensive, critical, well balanced info on diagnosis and treatment. The limitation of guidelines is it erodes your clinical skills or clinical ability to improvise or make you flexible, and it can limit your clinical judgment. And guidelines acts more as a ready-made cookbook, and we know there is no one cookbook for all the patients, so you have to individualize, you have to customize the care. So the mantra is customizing the care around the guideline is what every clinician should sensitize himself to. So the take home message is the guideline as a to be used as a verdict in the court of law is not self-evident. So guidelines is not taken as a mantra as or a prophetic document to pronounce anyone as being negligent. And guidelines are always subservient to the expert panel. So expert panel are put at much higher pedestal than a guideline. So the seniority, the academic standing or professional standing of an expert is what is valued more. But if guidelines are harnessed to a regulatory authority and it is linked to some insurance, then it may have some bearing. I think this is the phase which is evolving in healthcare. So you need to find out if any of your insurance companies are linked to any of the guidelines, because the reimbursements can be a problem if you have not followed guidelines, if it is linked to insurance or any other regulatory body. And it is expected that guideline makers have a dialogue with all the clinicians who are at a much senior level, who are caring for the patients, to take their inputs as experts before formulating any guidelines. And guidelines um, should value all the inputs that come from the clinicians, so that is also encouraged. And guidelines should take into the cognitive process of the clinician and then apply with discretion. And they do differ from textbooks, they do differ from the notes, or they do differ from the expert opinion, and that has to be recognized. And again, re-emphasizing, reiterating, guidelines have no managerial or legal mandate. And guidelines, the strengths, the weaknesses and relevance of the research has to be encompassed in the guidelines and has to be applied appropriately with proper interpretations. So thank you very much. I end with this cartoon. I'm sure you would have seen. So thank you very much. You can rehear to this lecture on my website www.drpradeeprangappa.com to gain more clarity and insights. Thank you.